Okay, well, let's take item 46A then. Guess there's some folks signed up on that. Okay, Jenny Jack, Louise McCarthy, Linda Rice, Diane Corwin. You the first four speakers?
Hello, I am Dr. Jeannie Harrison. I'm an obstetrician gynecologist at LAC USC Keck School of Medicine, and every day I have the privilege of caring for the underserved of this county. Before I continue, I would like to respectfully and sincerely extend my condolences to the families who are present today who have experienced a loss leading to the support of Prop 46. Having said that, sadly, Prop 46 does not guarantee adverse effects from taking place in the future. Prop 46 will not improve direct patient care. As someone who lives it day in, day out, I can tell you it will not improve direct patient care. Prop 46 will only raise healthcare costs in an overburdened, underfunded, and already fiscally limited system. This only actually negatively affects direct patient care. Finally, Prop 46 will increase medical liability, forcing providers, such as myself, to become more and more selective in the patients we choose to care for, and may encourage some providers to leave California and practice medicine elsewhere. All of these things, which ultimately affect the most underserved of the underserved patients, which currently I have the privilege and the blessing to call my own.
Thank you.
Good afternoon. Louise McCarthy with the Community Clinic Association of Los Angeles County. We are in support of your motion to oppose Prop 46. The Community Clinic Association of LA County represents nonprofit private community providers, 250 sites across LA, from the Antelope Valley to Long Beach, from Santa Monica into the San Gabriel Valley. They have been expanding to meet the demands of the Affordable Care Act, expanding to 20% more patients in the last 2 years, now reaching 1.3 million underserved patients across the county, many of whom are served in partnership with various county departments, mental health, social services, health services, public health, et cetera. As you all know, these nonprofit providers are operating at hairline margins and really struggle every day to open their doors to the patients they serve. They operate a staffing model, which means that they hire providers and they take on the full cost of providing their benefits, their services, their malpractice insurance. And so any changes to the MICRA law, which is what Prop 46 would do, would adversely impact the safety net, drive up the cost of providing care, and it would hamper access to our most needy populations. So with that, we urge you to oppose Prop 46. Thank you.
Sion Roy and Dr. Genevieve Claverell to join us. Go ahead, Mel.
Thank you very much. My name is Linda Fermoil Rice. For 35 years, I've been helping patients who have been victims of medical mistakes, preventable medical errors, as well as families who've lost loved ones because of it. In 1979, when I started this work, the costs associated with this litigation represented 1% to 2% of the $250,000 MICRA limit. Today, it represents anywhere from 25% to 40%. That means that of the $250,000 that might be available to a patient or a patient's family, roughly half of that is going to end up going to pay litigation expenses, the greatest expense of which, ironically, is paid to expert witnesses who are doctors who are necessary to litigate these cases. The patients that you want to protect are those that are least able to get legal representation when they are injured. They don't have any, most of them have limited economic damages, which are not capped by MICRA. The $250,000 limit, which has been in place now for 40 years, has roughly the value of $50,000 in 1975 dollars. And I don't think any of us here would think that a human life lost because of a preventable medical error would be worth the equivalent of $50,000 in 1975. The people you want to protect are also entitled to quality medical care. And we achieve that in some measure by holding healthcare providers accountable, just as we do drivers and truck drivers. I want to thank you for agreeing to continue this, the vote on this issue. We have a lot of additional information we would like to communicate to you. Proposition 46 is about patient safety, it's about
Thank you.
public safety, and it's about accountability.
Thank you.
Thank you very much.
William Shapiro, if you'll join us, and Teodoro Donoso. Yes, go ahead, Dr. Calabrero, if you want.
I'm Cheyenne Roy. I'm a cardiologist at Harbor UCLA and LA County Safety Net Hospital, as you know. I'm here to argue against Prop 46 because the patients that I treat every day, the underinsured, the uninsured, the neediest among us are the ones that will be most negatively affected by this proposition. Prop 46 is really three measures carelessly thrown together by trial attorneys with the hopes that adding sweetener provisions, as documented in the LA Times, will trick voters into voting for it. The real intentions are to increase the cap on medical malpractice payouts, and unfortunately, this will increase healthcare costs. The current independent legislative analyst predicts this initiative would cost local and state governments hundreds of millions of dollars per year, and a nonpartisan analyst predicts a $1,000 annual cost for every family of 4. What are the consequences of these increased costs? Decreased access for those who need it most, decreased access for my patients at Harbor, where resources, particularly in the outpatient setting, are scarce. Additionally, there are concerns for patient privacy and an ability to protect patient personal data with the massive expansion of the Cures database. The Department of Justice has said they won't be able to handle this increase in use of Cures if this initiative passes, especially because there's no increased funding for its operation. I'm absolutely sympathetic to the families who are here, who have their stories to tell, but this initiative is not the initiative that will improve patient safety. I ask the Board of Supervisors to join our broad coalition against Proposition 46.
Dr. Calabrero?
Yes, good afternoon, Dr. Genevieve Calabrel. I am totally opposed to Proposition 46, and for one main reason. Every time you mix 3 reasons to do a proposition, it's never a good proposition. Personally, I am in favor of the increase of MICRA. And actually, the state of Florida, I found it unconstitutional to have that. No. But Proposition 46 is a joke. To want to test physicians for drug and not test the nurses, not test, everybody else in healthcare it's absurd. And actually, when they had a press conference for this proposition, every physician who was involved were involved because of gross malpractice. None of those physicians were impaired. So why even, put testing? And when you come to Cure is probably the worst prescription drug monitoring system in the entire United States. And the only appropriate testing program is in Oklahoma. It's the only one in the entire 50 states who have up to the minute information. Cure, because is the software of that that individual rubber pack is totally inefficient. It takes sometimes 2 months to get information. And is one of the few states who report directly to the Department of Justice. All other states report to public health, which is much more effective. For all of those reasons, I feel we should vote no on 46. And it was an article in the Pasadena Star News yesterday, and my response to them for your information. And
Thank
if
you.
you go to my blog, theworldasIsee.com, there are multiple information why you should not vote no.
Okay, thank you. And then I would ask Eric Andrus and Tammy Smith to join
I
us,
said you
please.
should vote no. Did I say that? Yeah.
Next.
Thank you. My name is William Shapiro. I'm proud to represent victims of some medical negligence. I'm here to speak in favor of Prop 46. I realize that we have some of our people here that are encouraging against it. I want to start out my comments by celebrating each of you for celebrating the lives beginning that we had here for about an hour and a half. And as I sat here and I saw those lives celebrated and awards given, young people, old people, deceased people, I noted the value of life and the richness that those lives, that those folks lived in their life. And what it reminded me of is a client of mine, Nico Manzo, who's now 4 years old, who, because he was not given oxygen or was deprived of oxygen at the time of his birth, he suffers from cerebral palsy and he's a spastic quadriplegic. And he will never have the opportunity to have the life that we saw this morning in all these fabulous stories, because he will be in a wheelchair and while he has some mental capability, he will continue to suffer throughout his life, never having that chance. And back 40 years ago, back in 1975, when I was in my first year of law school, this legislative body that we have in California enacted MICRA. They call it the Medical Injury Compensation Reform Act. It's really the Medical Negligence Reform Act. It's not about medical injuries, it's about medical negligence. It's the only act that we have in the state that caps certain damages. In this case, we cap the damages of my client, Nico Manzo, who can only recover $250,000 due to medical negligence. What I'm encouraging is some fairness, and that is not only did we have caps, this law enacted did not provide for any provision for any increases. And when I started law school, it was $28 a unit. When my son started law school last year, it was over $1,000 a unit. It's one of the few acts and laws we have in our state
Thank
where
you.
there's not a built-in structure to increase
Your
the
time
burden.
has expired. Next, ma'am.
Thank you.
Good morning. My name is Tammy Smick. I'm a special education teacher with the Downey Unified School District. But I'm here today because I'm a grieving mom who understands all too well the devastating impact of medical negligence. This is my son, Alex. He was just 20 years old when he was killed by medical negligence. In an Orange County hospital, Alex was given a lethal combination of medications, and then he was left unmonitored for over 7 hours without even one blood pressure check. When he was finally checked on during morning rounds, Alex was found dead. He was already in rigor mortis. It was a twisted bit of tragic irony because Alex had entered that hospital to safely detox off of prescription pain medications. A pain management doctor had started prescribing my then 18-year-old son Vicodin, OxyContin, and ultimately morphine. So in my quest to seek justice and accountability, I sought legal counsel, and that's when I learned about MICRA, an outdated and unfair law that limits the value of my son's life at $250,000. And while there's no amount of money that will ease my pain and suffering, I want accountability for what was truly a senseless and preventable loss. But sadly, because of the MICRA cap, families like mine are denied access to justice. I find it utterly shameful that in California we have a law that is allowed to discriminate against certain segments of our population, including our children, the elderly, the poor, the disabled, and our stay-at-home parents. Take another look at Alex. He was one of more than 400,000 Americans who are killed every year because of medical negligence. but he was not merely a statistic. Alex was my son. And if this tragedy can happen to me and my family, it could happen to anyone. Please, I urge you to support the life-saving provisions in Proposition 46. Thank you for your time.
Thank you. Next. Alicia Cole and Darian Ojo. Join us, please.
Hello, my name is Teodoro Donoso. I am 60-year-old, and I'm mostly blind on my right eye. I've been told for a medical surgeon that I been blind because of medical malpractice. I was not working at the time, and so I have no lost earnings, and with the prop of $250,000 limit, I cannot get legal representation. My attorney, my family attorney, told me that I been turned down for many attorneys, because the limit of $250,000, so I cannot get legal representation. My family and I've been through hard times, and I really would like to say yes on Prop 46. It will help many, many people like me that go through medical malpractice. Perhaps in the future this law will pass and people will benefit from it. So very, very important for people like me that I am blind on my right eye, and it's so sad that I cannot take care of my family.
Thank you. Next.
Thank you.
Hi, my name is Eric Andrist. I live in Valley Village, California. In 2002, I gave up my career to care for my disabled sister, Callie. She was mentally retarded. She had the learning ability of a 4-year-old. This is my sister here. This picture on your right is shortly before she died of medical negligence at Providence St. Joseph Hospital in Burbank. I took her to the ER one night when she had a terrible stomach ache. After 15 hours of suffering, of horrendous pain, they still had not given her any pain medication whatsoever. It turns out she had a strangulated bowel that had burst and was seeping toxins into her abdomen, which caused sepsis. And this poor girl suffered for 15 hours without any pain medication whatsoever. When they finally gave her something, they gave her a drug called Dilaudid, which is 7 times stronger than morphine. And she passed out within seconds. But shortly before they gave her that drug, they gave her another radioactive beverage to drink for an unnecessary CT scan. Because of the sedative effect of the Dilaudid, she ended up aspirating that drug into her lungs, which caused pulmonary edema and sent her into cardiac arrest. The hospital was under the wrong impression that she was a do not resuscitate. So while she laid there in cardiac arrest, they stood around doing absolutely nothing. When they finally realized that she was wrong, they called a code blue. They were able to revive her 17 minutes later, but she was nearly brain dead by then. She died the next day. When I tried to get out to find a lawyer to help me with this case, it took me over 8 months to find a lawyer to take this case because they were all turning me down because of the MICRA law. It wasn't because my case was without merit, it was because of MICRA. I didn't know what to do. I was running out of hope. I finally did. I was one of the few people that lucked out and got a lawyer. But most victims do not ever get a lawyer. 22 states have no tort reform laws like MICRA. 13 of those have found it to be unconstitutional. What's going on in those states? They're not having any of these problems that the medical association is going to tell you is going to happen here if we pass Prop 46. So I'm urging you to please, please pass Prop 46.
Please. Raise your hands there. We don't allow applause. Thank you. Yes, ma'am. Go ahead.
Hi. My name's Darian Bojo. I'm an attorney. And I want to say, God forbid, should any of you or your loved ones suffer a significant injury as a result of medical malpractice and be faced with the possibility of only being compensated $250,000, something that may have been all right 40 years ago, but certainly is not reasonable now. You have no idea how many cases, good legitimate cases, cannot be pursued because of the expenses required and the extent of work. I don't take that many medical malpractice cases, but the last one I did have, because it really touched my heart, had costs of $150,000 to get it to trial for experts and everything else. But I'm here to tell you how that limit really works. One time when I did have a very clear case of where a Kaiser doctor didn't bother to look at a mammogram, and so he did not detect breast cancer, it was clearly worth $250,000. There wasn't any lost earnings or anything, so that's what it was worth. But the defense attorney said to me, well, we understand that it's going to cost you at least $30,000 to $50,000 to litigate this in costs, and you're going to have to put in at least $50,000 to $100,000 of work. So we never offer the $250,000. We would offer you something significantly less. So the $250,000 cannot even be achieved by someone who really deserves it. So thank you very much for your time and consideration.
Okay. Thank you. Next, and then I'd ask David Hoffman, John Denovi, Jeannie Harrison, and Susan Sabry to join us. Okay, go ahead, Ma'am.
Thank you. My name is Alicia Cole, and I'd like to thank you today for postponing this vote and waiting until you have a chance to take a deeper dive into the information. I'm here today to support Prop 46. As you heard, over 400,000 people a year die from hospital medical errors, preventable. We're not talking honest mistakes or bad outcomes. We're talking things that are preventable. But what we don't often hear a lot about are the over 2 million people like myself who go through medical harm and who survive and who are maimed. I went into the hospital in August of 2006. Providence St. Joseph, same hospital you heard another person talk about. My 2-day hospital stay turned into 2 months, a month in the ICU, 6 additional surgeries, almost having my left leg amputated, an open, draining abdomen for 3 years. This is what I looked like underneath my clothing for 3 years. It is 8 years later, and I am still in physical therapy and doctor's appointments every week. I am missing physical therapy right now to speak in support of Prop 46. My hospital was cited for being in violation of 5 state laws and 10 federal laws for unsanitary conditions in their operating rooms and not following their own policies and procedures. My doctor, I later found, had multiple cases of medical malpractice at the Burbank courthouse. Patients are going, your constituents are going into hospitals throughout the state without true informed consent to know that their doctors are on probation, to know that their doctors may have a drug and alcohol problem, and with the MICRA cap, now we are prohibiting those people from seeking justice and compensation. My medical bills were over $2 million before I ever left the hospital.
Thank you. Time has expired. Next.
Hi, my name's Jack Denove. I'm one of those greedy trial lawyers you hear about on the radio and the TV. And do you know who's paying for most of those advertisements? It's the medical malpractice insurance companies. So when people come up here and they tell you it is going to raise their medical malpractice insurance rates, you're educated people, ask yourself, why would the insurance companies that would profit from that in terms of increased premiums be so opposed to this? 40 years, it's been limited to $250,000. If $250,000 was reasonable in 1975, it is certainly unreasonable in 2014? Are we going to ask the Board of Supervisors to go back to, I think they were making $50,000 in 1975, to go back to that because it's going to cost us too much money to pay what your salary is worth today? Or tell police officers they should take a cut in pay because it's going to cost the taxpayers too much? But that is exactly what MICRA has done to the victims. They are limited to an arbitrary amount. And I've handled cases where I've represented doctors who have been addicted on drugs and continued to practice medicine, put people to sleep, monitor them, and then try to wake them up. And let me tell you, we may be lawyers or counsel persons, but we are all eventually going to be patients. And I want to have it to be sure that people are going to be checking the doctors like they do with truck drivers and bus drivers for alcohol abuse. Thank you.
Thank you. Next.
Hi, my name is Jeannie Harrison, and even though I'm an attorney, I don't do medical malpractice work for plaintiffs or defendants. I'm nervous to talk to you today because what I'm going to tell you is something I don't share with people. I'm the daughter of an anesthesiologist who is addicted and who is a fully practicing anesthesiologist, and he uses all day, every day, and I can't stop him. Something like Prop 46 could stop him. My question is, do you know whether my father works at one of your facilities? I would urge you to please, please vote yes on Prop 46. Do not vote against it. Sorry, it's nerve-wracking for me. One of the things that I wanted to bring up as well is that if my father, because he was using on the day that you came into the medical facility where he works, unfortunately killed someone in your family because of his addiction, then you would be limited to $250,000 in non-economic damages and emotional distress for one of those individuals that you love so much, for one of those individuals who has made your life so rich and so valuable. For example, with Joan Rivers, we know that she just passed. There's every indication that there was some kind of medical negligence associated with that. Because that incident happened in New York, her daughter Melissa and her grandson are going to be able to be fully compensated. That would not be the case if she had that surgery here. Thank you.
Thank you. Jeffrey Rudman, Alejandra Gonzalez, Joy Cole will be our last three speakers. Somebody will yell. Okay, go ahead.
Hi, good afternoon, everybody. My name is Alejandra Gonzalez. I'm here to vote for. I'm going to tell you my story. I'm kind of nervous at this time. My daughter passed away at 6 weeks of her birth due to medical negligence. First week into her birth, she got a slight cough. Took her into the pediatrics, fine, sent me home. After that 5 weeks, her last week of life, I took her into her pediatrics and emergency room 5 times out of those 7 days. 5 times out of those 7 days, I was sent home. No labs were done. No x-ray was done. Nothing was done. Being a big epidemic at that time of the whooping cough, my daughter passed away of the whooping cough. Till this day, it's been 4 years and it still hurts like it was yesterday. That doctor's still practicing. Those emergency room doctors are still practicing. It happens every day. I was one of the lucky ones that did get an attorney. That came out to be the MICRA law, being at 250. My daughter's life isn't worth 250. Thank you.
My name is Joy Cull. Olivia was our firstborn child, oldest of 3. At 17, Olivia was accepted early to Smith College and had already set her sights on graduate school. On January 9th, 2009, she was scheduled by her cardiologist to have a routine diagnostic procedure, a heart catheterization at UCLA's Ronald Reagan Mattel Children's Hospital, which she had had a half dozen times before, to monitor her congenital heart defect. This procedure, again, is routine, performed literally millions of times a year in the U.S. People don't die from this test. It would be like dying from an MRI. It's a diagnostic procedure done in a lab on infants, the elderly, and everyone in between. No one had ever died from this procedure at this hospital ever. Olivia never came up to recovery. The doctors said she suffered catastrophic brain damage and was taken off life support several days later. Because of the MICRA law, we still don't know fully what happened. We begged the chief of physicians to investigate, and he assured us he would, then never called us back. We then reached out to a law firm who, because of the 250 cap, was unwilling and unable to depose all 7 or 8 of the personnel in the lab at the time of Olivia's procedure. We were given vague and conflicting reasons for her death, even while the doctors were under oath. There was at least a 20-minute period where Olivia was still under anesthesia and not monitored. Where was everybody and what were they doing? The physician in charge came into the procedure an hour and a half late, and no one can attest to his whereabouts after he left towards the end of the procedure, even though he stated this was his only case that day. We've heard that the monitor was turned off. No, the monitor was on, but the alarms had been turned off. We heard CPR was done incorrectly and pushed blood into her brain. One nurse testified that the code blue chart, which had been presented as an accurate second-by-second account of what happened, was actually filled in hours after the episode, and that the whole chart was made up. The most excruciating testimony was that of the first anesthesiologist. When she came back into the room, Olivia's head and neck were blue and swollen. She immediately began CPR, and Olivia was revived in a minute or less, which means she could have been resuscitated earlier and wasn't. Because of the MICRA law, we can't get any closer to the truth or hold anyone accountable for our daughter's death. Our lawyers dropped us at one point because I was pushing to go to court, but the firm couldn't afford to do that. We had to settle out of court for the cap amount. These doctors are all still practicing, most at the same hospital, many with promotions. Not one has a mark on their record. They play golf and go on vacations, living their lives, and most importantly and shockingly, are all still practicing medicine at a children's hospital. These doctors caused the death of my daughter, covered it up, and got away with it. Please
Ma'am, if
vote
you
to
just-
support
okay.
Prop 46.
Thank you. Gary Schneider.
Good afternoon. My name is Gary Schneider. I am an attorney. I've been an attorney for about 38 years, which is right around the amount of time that MICRA's been in effect. When I started, I got my first job. It was at $15,000 a year. That, of course, has been adjusted for inflation, but MICRA never has. I have a client here with me. His name is Peter Spencer. He was taken to Kaiser because he was suffering from shortness of breath. In doing a test on him, technician was injected into him, which blocked his radial artery and which caused the amputation of his thumb, index finger, and middle finger of his right major hand. He also developed systemic infections that he still suffers from. He has had lengthy hospitalizations. He has had lengthy rehabilitation. He went in because he had shortness of breath and he came out without his hand. I'm also one of those greedy trial lawyers speaking for the victims of malpractice because they need to be spoken for. And it is time, if there has to be a cap, which we even think there should not be at all, it is definitely time to adjust it for 40 years of inflation. The world will not come to an end. It will continue, and in fact, by increasing accountability, by making the medical profession, the hospitals, the doctors, and all the practitioners accountable, it will certainly make them more careful. Right now, with this cap, they're virtually acting with impunity and no consequence for the harm they cause. Thank you.
Thank you. The item is before us. Did you still need a continuance, or really, you want to do it?
On it yet.
Okay. All right, then we'll continue for a week. Gonna continue for a week. They both asked for a continuance. Okay.
The continuance for a week, Mr.
1 week.
All right. Is it reasonable to share some information at this point and to pick up the balance of the discussion next week?
Okay.
I would like to.
If you want the, yeah.
Share a document for all the board members to at least to be apprised of in the event that that isn't the case. Going back to. Going back to December of 2007, when we have from the CEO's annual report to us referring to what our legislative activity ought to be. Take note of item number 14, where it calls for the opposition to legislation that would revise, MICRA explicitly says, to impede access health care costs and/or divert healthcare dollars from patient care. Legislative session 2009. Take note of point number 13. They oppose legislation that would revise the Medical and Injury Compensation Reform Act, otherwise known to us as MICRA. It essentially speaks to impeding access, increasing healthcare costs, and/or diverting healthcare dollars from patient care. 2013, 2014, our most recent treatment of it, and the same was the case in 2011, 2013. The point is made there as well. Any indication that this is a new item for the board is simply unfounded. Mr. Chairman, I think the fact that CSAC, the California State Association of Counties, took a position of opposing Proposition 46 is noteworthy for us to consider. Not a new issue, compelling issues on both sides of this argument. I take that to be seriously. No one wishes to demean the tragedies of any family that has experienced such circumstances. The fact of the matter remains that the board for the past several years has had it as its standing policy and opposition to such as it comes forward in Proposition 46 is not to be considered a surprise at all. The county's safety net is, of concern legitimately. The concerns that have been raised about the legislation, the initiative as it has come forward, is up for debate. Not a new issue, nothing surprising about this. If there's a desire to continue the item, we ought to respect the request of those who wish to continue it. But I wish to say nothing new here, consistent with longstanding board policy.
I don't want to get into the debate now. Let's reserve that till next week. But I just for the record, there are some people, myself included, who may not believe that this proposition will impede access, increase health care costs, and or divert health care dollars from patient care. We'll have that discussion next week, and I think some of it was foreshadowed in some of the testimony you heard here today. I don't think there is necessarily anything. We now have a specific initiative that's before us on the ballot, and we'll have that discussion next week. In the interest of time, we'll just hold off that. But this does not suggest there's nothing inconsistent about this and a new de novo view of Prop 46. There's some who would argue to the contrary. Some who will argue your point of view.
And that's fair.
Right.
But
So anyway,
there's a legitimate discussion here.
I'm just not, let's leave it till next week in the interest of time.
Right. There's a legitimate discussion. People can and do differ, but the fact remains that the position of the county for some years, this board, has been to oppose MICRA reform. It may choose to do otherwise in this instance. But any representations, is there something new, different, emerging here, is simply unsubstantiated, factually in error.
You continue for 2 weeks? Yes.
A very troubling issue on both sides, and I know that's why I want to take the time to think about as to how we proceed. We in the county operate at both levels. First of all, we pay out the liability of malpractice. We indemnify all of our doctors and our surgeons and our anesthesiologists. That's what we do. And so consequently, it is an escalating cost, and I certainly have been a critic of the escalating costs of medical malpractice. But the other aspect of it is when you break down some of those issues, the troubling part about it is, unless there is accountability, those things are going to be recurring. I have been a big part of proposing corrective actions here in Los Angeles County when it comes to the medical malpractice issue. I remember being here less than 30 days, way back in 1992, and I got a call from a lawyer who was pretty upset with the county because her client was in the process of going through a series of depositions, and she had brought in a baby at Olive View, and of course the baby had died in the emergency room. She had delivered the baby 4 days earlier at Olive View and had been released to her, and so the point is that she was released without an anal opening, which is a violation of law. So when she brought the baby back, of course, the baby died. But the questions that were being asked at that time of this young woman was, where did she get the fetus? Because this certainly wasn't the same baby that was released that day. Well, it was interesting. The lawyer was pretty angry about why we were pursuing this. When I talked to the lawyers, they told me that I said, I don't think we have a defense here if we release the child and then now we're trying to cover this up somehow. So I've been on both sides of this issue. And unless she would have had a lawyer to be her advocate, this 17-year-old would have nowhere to go, because our position at that time was that this 17-year-old must have found another baby to bring in and to die in the emergency room, which was really odd and strange. So I have seen medical malpractice from both sides. I've also seen when we have settled a case, which I didn't think should be settled, and I argued with the lawyers as to why we were settling, because in fact there are medical accidents that occur, and they are truly accidents. But when I heard the lawyer tell me that if we went to court, we would have to admit that we did not follow the standards of care, we would lose the case. Well, I find it hard to believe that any doctor would be practicing in LA County not following the standards of care. Why we would defend that, I don't know. So I'm on both sides of it. I've seen the escalating costs. I don't know that that necessarily should be tapped on to those issues. But I am very concerned. I'm concerned here in LA County, and that's why we have our corrective actions. I'm not sure yet where to fall on the side of this. I'm concerned about it, but at the same time, I do know that there has to be accountability. There are a lot of lawyers that'll run into court with any, broken toenail that they can find. But there are really a lot of legitimate folks that without access to a lawyer who can at least recover cost and get something for the work that they do, many of the people would not find the ability to find a lawyer or get someone to respond to their issues. I haven't decided where I'm going to sit on this. I don't think the county should be taking a position at this point. I think it's a very personal issue, and it really has, I think, compelling viewpoints from each one. But we sit here as someone who has to pay with taxpayer dollars these increased medical malpractice, but we also stand as responsible people who should make sure that we are curbing the problems of medical malpractice where they start, and that is in our hospitals, in our clinics, and we need to hold doctors accountable. As you remember clearly, about 4 years ago, I had a battle with a couple of doctors because they weren't reporting these incidents to the state. So accountability works on all levels. Unfortunately, there are many instances with many institutions that don't hold the doctors accountable, and very frankly, they can be very cavalier. They aren't like the kind of doctor that we just talked about earlier, Dr. Nuno, who was very responsible and someone who took action and spent hours upon hours. So it's a troubling issue, it's a difficult issue, and very frankly, I know it was on the green sheet, but I haven't made a decision, and I'd like to have an opportunity to do so.
It'll be a week then. Thank you.